Hear him
So
really
are we gonna be
clearly.
on the recording? So picture?
Are we gonna picture them?
No.
Yeah,
If you
I don't have
see
to be respectful.
where I'm waving my hand, it's that owl in the middle of the table.
And the
We'll
owl
put up
will
your
pick you up
picture.
on there, so they'll. see.
You're not in it.
But
So, okay, we're not in it. When you're talking,
Yeah, we don't want.
it will, you'll be the.
Okay, so go to me when I speak.
It will.
It said we don't need to.
Um, If someone talks to me over there, I'm like, all right, I
Yeah.
can't use the owl, I haven't used one.
Right.
Very good. And then Mary, is it prefer I keep my mask on or think about, I'm happy to respect people's wishes, so.
I think probably on, is that what your preference
I
is?
would prefer it with my picture, if that would be okay.
Are you, do you feel
I'm
comfortable
fine. I mean,
protected?
So from my perspective, I just, whoever I'm meeting with clients or anyone who wants to meet with me, I defer, so.
Yeah.
You just have respect, so if you'd like me to wear it, I'm happy to wear it, if not, just know it might be more difficult to hear me, if not, I'd have to repeat myself or clarify. So let me introduce myself, my name is Mark Andres, I'm an attorney. My primary practice is estate planning, tax, succession planning. So I get involved with drafting estate plans for clients. Additionally, assisting clients if they have family members who have healthcare needs and they need assistance, whether it be through the power of attorney documents or guardianship that may have to be petitioned. Additionally, I assist with post-death administration as well as ongoing trust that I either am the trustee of or I assist the trustees for ongoing trusts. So I've been practicing for 21 years. I had the great pleasure of working for a couple of years with Tom Mountain, and Tom shared that he was diagnosed with ALS a number of years ago before he retired from our firm at that time. And then subsequent to my work with Tom, I joined Davis and Kuelthau, where I've been a shareholder, and we actually just merged. We're now part of a new firm called M.B.A. Davis. So we went from being about 55 attorneys to about 230 attorneys in 5 states. But my practice still continues to be focused working on individuals, families, small businesses. And my primary office is in Brookfield, but I also work out of our downtown Milwaukee office. So for purposes of the presentation today, Mary, thank you for reaching out to me. I have spoken to this group before. I think I look back at my notes, it was about 4 years ago. So
It was a while.
yeah.
Yeah.
Lots happened in 4 years. hasn't it?
Oh, my goodness.
Indeed. So happy to be back, and I prepared a presentation that really gives an overview of estate planning. Understand that everyone here might have different knowledge. So some of you may already have an estate plan in place. Maybe none of you have engaged in planning, just want some basic information. So I come to this kind of just to lay a foundation, and then we'll open it up for questions. But before, and then I do have some slides that go circulate, but before I launch into my presentation, happy to ask everyone present in person as well as online, if there's anything in particular you'd like me to address today. So just go open up to our raise your hand, share if there's anything in particular you'd like me to address, and we'll make sure that we address that as best as possible.
You said you had something.
Yeah, I have we have a daughter that we'd like to, make sure that her college is all paid for and that sort of thing. My wife does have, savings tied up. That we might want to sort of take out right now because she can still sort of get around with our daughter.
Right.
So I want to do something, and obviously there's, tax education.
Certainly. Very good. I'll address that. I'm just going to make some running notes. And so just make sure I touch upon those things. And then after I kind of give an overview, obviously we'll have a conversation, open up for questions. Is there anything else in particular that anyone wants me to address today or talk about?
What attracted me was the protecting your assets. I know this is going to be a rocky journey and financially it's going to be pretty hard. So I'd like to find out more information about that.
Very good. All right, we'll be addressing that.
And we only have a will. Do we need more than that?
All right, we'll definitely address that.
And how about the Title 19 effects on assets?
We will address that as well.
They have them too. I have like medical power of attorney for my husband,
Okay,
but do I need to also seek out like a guardianship or other forms of power of attorney? I'm not sure. I'm a little confused.
okay, we'll address that. Fair enough. Any other points you'd like me to address, either here or virtually on the video screen?
If anyone on the Zoom call has a question specifically, you can unmute yourself
Or put it in the chat.
or put it in the chat. Thank you, Kathleen.
Kathleen, are you monitoring the chats?
I am.
Okay, very good.
I'll be sure and
let
you know.
In addition to being acquainted with Mary and also Tom, I also have the good fortune of getting to know Kathleen because we serve in a nonprofit board together, so. Happy to
I'm
see
very
you.
lucky.
Small world.
Face.
It is.
Yeah.
Great.
All right, so let me begin. And so I create copies here, for purposes of those who are attending via Zoom. I can give you a copy if you want to email those to whoever's in attendance.
Yeah, I'll just scan it and add that on.
Circulate that around. Mary, I'll email you a PDF.
Okay,
when I get back to you.
either there, I could just scan it.
Okay, whatever you prefer, but
Yeah.
the PDF might be.
Thank you.
easier.
Okay.
Right place here.
Thank you.
All right. So you can see I have, my basic, my contact information there. So what we're going to cover today, we're going to basically just have a general overview of estate planning. We're going to touch upon some of the questions or concerns that were already raised.
Is it okay if I dim the lights?
Uh-huh.
That's fine with me. I might,
That's it, does that help that?
I didn't bring my views in this one. So basically, I want to give an overview of what I consider comprehensive estate planning, and then we'll kind of delve into some of the issues that were raised here. Also, I think particular to individuals and families who are facing ALS. I've had the pleasure and the opportunity to be of service to a number of clients over the years who have been diagnosed with ALS. So have dealt with a lot of planning considerations. So I'm going to cover the goals of effective and efficient estate planning. Kind of what we do for planning now. A lot of people maybe have a concept of, having a will. We'll talk about wills versus trust and the impact of that and how estate planning has evolved. Asset protection will definitely touch upon that. Planning for long-term care, and that kind of dovetails into, Title 19 Medicaid planning issues, probate and how to avoid it, and the pitfalls of avoiding trust. So I always kind of like to start these presentations by talking about what are we trying to achieve with effective estate planning. People want to give what they have to whom they want, the way they want, and when they want, to manage the risk of incapacity, making sure that we have decision makers to act on our behalf or on behalf of our loved ones, to delegate healthcare decisions to appropriate parties, provide for the needs of a surviving spouse, loved one, or partner, or child, to provide liquidity at death, to provide for charitable intentions, to promote family harmony. If at all possible, we try to achieve that. Not always possible, unfortunately. Plan for children, including children or incapacitated individuals with special needs, and protect assets from creditors. So basically, we're trying to have efficient transfers to minimize cost. That includes probate, includes exposure to taxes. We'll touch upon the fact that most states now are not really subject to an estate tax. So that's generally not a huge consideration, but there is income tax exposure and how to provide for that. And obviously want to avoid fees. Clearly, much of my work is assisting clients in planning, but we don't want to have any more excessive fees than necessary to put together an effective plan. And ultimately, we want net assets distributed to loved ones and the maximum effect of your intent. So the core of a typical estate plan nowadays is a revocable living trust. with no plan in place, no documents, no will, no trust. Basically, your assets are distributed under the state laws. The law has been tested. It usually goes to a surviving spouse. And then if there's no surviving spouse, to your heirs, your children. And so if you don't have any plans, we're gonna follow the laws of Tennessee, probate would be opened in court if you have over $50,000 of assets in your name at death. And we have the probate proceedings. Now, if you want to express your wishes regarding how your assets are transferred, you would have a will prepared and executed. Your wills are written instructions regarding how your assets distributed at death. The will does not become effective until you pass away. It can be revoked, amended, changed up until death. We have to have valid execution, meaning you have two disinterested witnesses. And a will by design is to be admitted to the court to give instructions, telling the court this is your wishes, and the courts to oversee how your wishes are carried out. And that is the probate process. The probate process invites any creditors or claimants to come forward and say, this individual, while they're alive, they owe money, or for any unknown heirs, or, to say, we really have a claim to this estate. So probate's this process where if you don't have a will, your estate is going to be administered. If you do have a will, the court is going to oversee how your assets are distributed upon death. In that process for probate generally could be a year or two, or longer. But because the statutory deadlines for creditor claims and whatnot, it has to last usually about at least 6 to 9 months, usually a year or more. So most people want to avoid the probate process because of the time involved. Additionally, it's everything before probate. The probate court is public record. So basically, all your assets will be, declared through an inventory and accounting. Anyone can go to the courthouse and obtain that. Basically, there's just continuous oversight until your affairs are wrapped up. So a lot of people want to avoid the time, but also don't want the public view of that, and don't want to have a third party, a judge or commissioner overseeing the administration of their estate. Additionally, most people are interested in reducing their exposure to taxes. As I started this conversation, the state tax exemptions, which we'll go over a little bit here, are very high. Less than 0.5% of the United States population is subject to an estate tax. Now it's going to be next year to be $13 million for an individual, $26 million for a married couple are exempt from an estate tax. So we're really not doing much with estate tax mitigation, but we are being mindful of how limit exposure to income tax, which, as I share with my client, we do estate planning. So we all know you have to file income taxes while you're alive and well. And unfortunately, after you pass away, your estate has to file income taxes as well for any income you generate after you pass away. And then, the final piece here, asset protection. In the context of drafting a revocable living trust, there's limited asset protection for yourself or your spouse, but for any beneficiary, we can create a level of asset protection because if you want to leave assets for a child or any other beneficiary, if you hold it in trust for their benefit, it's not their asset. So if they have a creditor, a claimant, a divorcing spouse, a bad business dealing, if it's held in trust for their benefit, that those assets are protected from third parties. Whereas if they receive an outright distribution of assets, any creditor, claimant, divorcing spouse can have a claim against those assets. So we always might be mindful of asset protection. In the context of asset protection and long-term care needs, sometimes we take a more aggressive posture, which is if we put assets in an irrevocable trust. Now, without being able to show my lips, it just will emphasize irrevocable, irrevocable trust, one that can't be changed, modified, amended easily. Those take assets outside of your name, in your ownership, to basically make it give a level of asset protection from creditors or claimants. And so sometimes what we'll do is a very aggressive, planning tool. Will recommend to clients to put their assets in an irrevocable trust that they don't manage or control. Typically, those can be for protecting from claims against Medicaid, Medicare, and it could be known as Medicaid Asset Protection Trust. I generally don't go down that road too often because it's fraught with a lot of liability. And in the context of obviously a meeting here today with an ALS support group, unfortunately, I know, the timeframe for life expectancy for someone diagnosed with ALS. And the key with these Medicaid Asset Protection Trust is the assets have to be outside of someone's estate for at least 5 years to get the full benefit of the asset protection. And if it's not held outside their estate for 5 years, there's a look back period to recover assets.
So Mark, I have a question in the chat. Is it okay if I ask it?
Please go ahead.
Is it better to name beneficiaries for IRAs? Or address it in the living trust?
That's a great question. I don't want to get too far afield, but I'll answer because it's been asked. An IRA, an individual retirement account, is a unique asset. It's how it's characterized by, particularly for the Internal Revenue Code. Generally speaking, you want to name your surviving spouse or partner as the primary beneficiary, and you generally want to name contingent beneficiaries, whomever you want, oftentimes as adult children. And the tax benefit there is if you name an individual as a beneficiary of an IRA, and truly just an IRA, I'm not talking about 401ks, I'm not talking about brokerage accounts, 403B accounts, we're talking about IRAs. We want to name generally a primary beneficiary, oftentimes a spouse or significant other, and then contingent beneficiaries, oftentimes those are children, adult children. And the reason we do that and not name a trust as a beneficiary is then the individual beneficiary, upon the death of the account holder, is able to stretch the distributions over a period of time. You used to be able to stretch those distributions over the rest of that beneficiary's lifetime. About 2 years ago, since I've been here last, I've spoken to this group, they changed the law. And there's exceptions, but by and large, a beneficiary needs to have the full assets distributed within 10 years. So the beneficiary of an inherited IRA, so you have let's say it was a traditional IRA, and then the account holder passes away, it becomes an inherited IRA, and it has a unique nature and regarded differently under the Internal Revenue Code. And an inherited IRA then has to be distributed within 10 years. And those distributions are subject to basically required minimum distributions calculations, or RMDs. So that's probably a little more technical than maybe the questioner was hoping for, but I wanted to answer the question. So it was posed. Long short of it, IRAs, you generally name individual beneficiaries. It's really for tax reasons. Oftentimes you would otherwise name your trust, and we can talk through that a little bit later too. Yes.
During those distributions, excuse me, are those counted against your income?
So if you take a distribution from an IRA, an inherited IRA,
Inherited.
you're going to get taxed on it. And the whole concept is, but that's the required distribution is designed that to take the distribution and then to collect the tax. From a policy perspective, the reason why they got rid of the lifetime stretch compressed to 10 years is they didn't like seeing that the treasury wasn't getting paid taxes upon those distributions. People were just keeping them in inherited IRAs for 20, 30, 40 years. You know, if a beneficiary was like 30 or 40 years old, 50 years old. So they said, no, we're not gonna allow that anymore. You know, we're gonna require these beneficiaries to take the distributions within 10 years. And then, yes, that's income, because by its very nature, that was income that was never taxed. You get tax deferred growth. And so it's taxed upon the distribution, whenever you take it. It was, I don't want to get too far afield, but interestingly, the law was drafted that you had 10 years to distribute. So people like, well, I can wait till you're 9 and a half, 9, 10. And about 6 weeks ago, they finally clarified in the regulations that no, we really are saying you have to take you have to take distribution every year. Like you can't just, wait until you're not.
So then if you put that IRA in the trust, then it's different.
Yes, and oftentimes we don't recommend that. There are, you can't have an IRA but generally by its very nature, an IRA is an individual name. I don't want to get too far on that path because there's
Okay.
nuanced trusts that you can do an IRA trust, but generally you would keep an IRA in the individual account holder's name. And then you name individuals as beneficiaries for tax reasons. Otherwise, you even lose the benefit of a 10-year stretch, you get compressed down to 5 years.
Okay,
So that's from a tax planning perspective. You have individual beneficiaries. The only distinction there would be if you want to add an asset protection, you can discuss that, but
My husband wants to know about stepchildren, but I'm not really sure what that really means. We have stepchildren.
okay.
Are those, if you name your children as beneficiaries, does that include stepchildren, or do you have to
So
stipulate that? Or-
you can identify in your documents whether you will, trust, or beneficiary forms, whomever you want to receive, whether they're a child or stepchild. If you have no documents, though, a stepchild who's never been adopted is not regarded as an heir under the law. Okay, so if you have a stepchild, the laws of intestacy kind of goes back to common law in England, and basically the laws of intestacy are bloodlines. So basically, you're looking to see who has the bloodline back to the decedent. And so that we carry that common law tradition with us from England, the United States. The laws of intestacy are truly, we look at the bloodlines. What basically addresses that is adoption. So if a person, so anyone, my clients can name anyone they want to be a beneficiary in their will or trust, the beneficiary forms, whether they're a child or stepchild. And that's a contractual right. So once you've done that, that addresses that. But without that being stated, if you have no documents and not otherwise defined, a stepchild is not seen as a natural heir, and therefore not entitled to a share of the estate.
So document is in a will or a, are you saying, or as a?
It could be in a will, a trust.
Trust, okay.
If you name a particular individual saying, I regard this person as a child to be treated as such, or should get, 1/4 share, then they will, that's a contractual right. But without stating that, a stepchild does not get that, have that same legal statement.
Thank you.
No problem. Good questions. I'll keep going, but I kind of have a little bit of give and take of like, we'll go through the presentation, but I also think it's really important to talk through some of these questions that pop up. We talked a little bit about probate, it's public. Generally, you'll hire an attorney, go through a probate. And also just, it can be expensive too, frankly. So oftentimes clients say, well, Mark, I don't, I just want like a, basic will, whatever. Maybe I want to avoid a trust. A trust will cost a little more time and be more expensive. That's still more economical than going through probates, which generally takes, a significant amount of time because you have court hearings and documents to prepare. So generally speaking, from a value proposition, best to do your planning up front rather than have your estate, incur the expense. I've also had clients over the years say, what do I care? I'm going to be deceased and my estate will pay for it, but your loved ones may not appreciate that. So we talked a little bit about the evolution of planning. We used to, traditionally, really the foundation of an estate plan was a will. We've kind of gone over the last 30 years or so to having revocable living trust to avoid probate principally. And then when it's estate tax exemption for lower, which was even, 10, 15 years ago, we definitely saw the tax benefits for local living trusts, but the long and short of it is, we've migrated more to the foundation of an estate plan being a revocable living trust rather than a will. We'll go through.
Can you see all right?
I'm going through the fact that I'm just trying to navigate with my, the prints, and my glasses are fogging up. And I generally don't wear, the funny thing is, Up until the spring, I never wore glasses because I started to wear years.
Tried to put-
Yeah, so my eye doctor, who happens to be my brother-in-law, just tells me it's just getting, I'm getting older.
If you pinch the top of your mask a little bit, it might help not let the moisture in there.
Yeah. Pretty good. That helped.
Doing this for years.
So, I don't want to get too much more legal mechanics here, but traditionally, when we started doing multiple trusts with lower exemption levels, basically, upon the death of the first spouse, we had a joint trust split in two, and basically that would maximize, let's say the exemption level was, I almost put a low one out there, we'll say $500,000. What you would do is you would, in order to maximize or limit the exposure to state tax, or maximize the benefit to the surviving spouse. Upon the death of the first spouse, you would fund that one trust would split in two. $500,000 would be put aside in a separate trust. We have known that they were known as AE trusts, and then you would have a second trust that would basically go to the surviving spouse, and that would basically limit the exposure to estate tax. Typically now, we don't have to split those trusts upon the death of the first spouse, but we do have that option available to us if we need to, if the estate tax exemption goes down. I think that's really about as far as I want to go with that because of the current status of the state tax. Additionally, over the years, I think we became aware of popular cases with Nancy Cruzan, Terry Scheibel. These were cases where someone didn't have clear healthcare directives. And so it got litigated as far as who is going to be directing someone's care and treatment. Under the law, generally a spouse has deference as far as directing a spouse's care and treatment. We still want that clearly addressed in the healthcare power of attorney document. But the key there is in the absence of not having clearly defined your healthcare agents in the healthcare power of attorney document, you're going to be inviting a potential for a court proceeding, a guardianship, to appoint someone to direct the individual's care and treatment. So if at all possible, we want to avoid a guardianship by having up-to-date and current healthcare power of attorney documents that clearly express one's wishes regarding who should direct their care and treatment, and particularly what their wishes are regarding end-of-life care and treatment. And then if there's no one able to serve as a healthcare agent or someone nominated, we can also produce living wills, also known in Wisconsin as advanced declaration to physicians, as part of your advanced directives. And that basically speaks directly to your healthcare providers regarding what your wishes are for end-of-life care and treatment. Going on to the next page here, it's slide 11. Just to highlight here, I talked about most states are not subject to a estate tax now. I put in the 2023 exemption level. They just released that a few weeks ago from the IRS. So basically $12.92 million of anyone's estate is exempt from the estate tax. If you're a married couple, you double that, so essentially $26 million. And it would be a maximum of 40% gift estate tax rate. So what effectively where we are right now in the law is very few, if any, people are subject to estate tax, and those who are have probably engaged in pretty sophisticated planning to not have to engage with it. Please know that many of us believe that exemption level will change again. There was, sooner than later, about 2 years ago, there was a lot of talk about lowering the exemption. And eventually they did not land there. The trade-off was right now we get the benefit of what's known as step up in basis. So if you die and you have significant capital gains you realize over your life, the value of those gains are stepped up at your death, and therefore your beneficiaries, your heirs, don't have to pay that capital gains on those assets, whether it could be as simple as real estate, your home, that could be, or stock you held, or business ownership interest. So that's a very significant tax issue. A lot of people don't even think about it. Well, 2 years ago, they were saying, you know what, we're thinking about getting rid of the step up in basis. And now we're going to tax people or their estates on the capital gains they've realized throughout their lives. And so it's a trade-off of, or, probably if you get rid of the step up in basis, maybe you keep the high exemptions, but otherwise the alternative is probably to lower the exemptions. And as a practical matter, I mean, at some point in time, I think we expect the exemptions will go down. They are supposed to sunset here in a few years, but that just means that they renegotiate by Congress. So anyway, stay tuned to that, but I guess the big takeaway is, yes, there is a estate tax that people can be subject to. Very few Americans are subject to one now, but please know that may change. And, as recently as 15 years ago, it was down to like $1 million exemption. And that's, a lot of people have $1 million estate factor in their home. Let's say they have life insurance and they have retirement accounts that would be subject to an estate tax like they had been, not in the not too distant past. So anyway, planning for 99.7% of Americans who are not subject to an estate tax. Once again, basic estate planning, providing for your loved ones, your family, and doing those things we've already discussed: family harmony, asset protection, and income tax planning. We already kind of talked through the issues here on slide 13 about what is intestacy. We talked about, natural. We look, under common law, we look at bloodlines. And if you die without a valid will or a trust, we're governed by the laws of intestacy, in state by state. And basically, if you don't have an estate plan, I guess the old adage is you actually do have a plan that's governed by the state of Wisconsin or the state where you live. You get a chance to indicate what your wishes were. If anyone has property in different states, please know that the property in different states is subject to those states as well. So I'm not talking about necessarily investment accounts, because wherever you reside, those can be governed by that state. If you have, for example, I'm working on a matter, the family has a property, but there was a home in Wisconsin, suburb of Milwaukee, and there's a property in the Upper Peninsula of Michigan. So we're gonna have to have a probate actually probably now we already have one in Wisconsin, we have one in Michigan. So I have a lot of clients who are in Florida, Arizona, so sometimes they have a probate in both Wisconsin and Florida, or Wisconsin and Arizona. So just know that particularly real estate triggers have a probate in that jurisdiction. The way you can avoid that is by having that property in a trust, because a trust can basically dispose of the property without going through probate in that local jurisdiction. One thing, we'll touch upon, the question was posed about providing for children, if you have a young family or any minors. So clearly, one thing we address in estate planning documents is who be guardian for children. If one or both parents are not able to be the guardians for their children. So we generally address that in the will documents. Please know that even if you have a trust or remote living trust, you oftentimes have wills in conjunction with that, which basically say, I have a trust, in my efforts to not have to go through probate, but I'm also appointing set individuals to be guardians for my children or my family. I think we're already touched upon some of the aspects of a will-based plan on slide 13. We talked about the pros of a trust-based plan versus a will-based plan and avoiding probates. Sometimes there actually are instances where you would actually want to have the probate court involved, and that's really where you want the final order of a judge or a court to basically get closure to this. That's not too often, but it happens when things are litigious. Also, sometimes if you have a relatively small estate to administer, or assets just that are not in the trust, and they're not going through beneficiary designation, or you might have, there's some summary procedures you can have just to transfer the asset with supervision. And that's when, a will-based plan might be, beneficial. But that's generally speaking, a living trust is probably preferred, in conjunction with formal wills to have ease of administration and to reduce costs, fees and expenses. One thing that was touched upon was, retelling assets. I kind of alluded to it already, particularly with the IRA question, that came up. Basically for anyone who has life insurance, or retirement accounts, you generally can name beneficiaries on those documents. And oftentimes that works well. In a life insurance, retirement accounts, particularly 401(k) accounts that have beneficiary designations, that is a matter of private contract between you and the financial institution. And therefore, those assets can transfer outside of probate, outside of court supervision, and outside of a trust. The challenge with that is sometimes you want those assets to actually flow through the trust. So mainly for asset protection. So for example, this morning I met with a gentleman whose wife passed away at a very young, relatively young age. Unfortunately, she had COVID and she passed away. And the whole issue there is they have minor children, they have one adult child. And so in those instances, oftentimes what we want to do is have assets, they can't go to the minor beneficiary, but we want them, oftentimes we want those assets held in trust until that individual is 25 or 30 or 35. So those assets are there for the benefit to pay for tuition, room and board, health, education, maintenance, support. And then when a certain age, distribute it out. So yes, you can do a lot of retitling of assets or beneficiary designations without a trust. However, oftentimes you want to have a trust for the asset protection component. And then also, I have here on slide 18, concerns about, if their spouse remarries, if it's not addressed in a will or a trust, having the beneficiaries changed, inconsistent with the wishes of the deceased spouse. Additionally, unfortunately, I come across cases over the years where someone said they updated the beneficiary forms, but we can't track them down. I believe it's a bigger issue too nowadays with anyone who has like employee benefits. You oftentimes like click buttons and you choose your beneficiary and it just kind of up in the cloud. And so I always encourage clients, like if you do fill out beneficiary forms, even online, like make a printed copy. If they're my clients, I say, I'm always happy to have that in the file. I've had clients who said to me, I could have sworn, my family member, my loved one, my mom, my dad, or my spouse, they filled out the beneficiary form, but they can't track it down. And now it's just going to go to the estate, which means we end up having probate. So, whenever we do an estate plan, it's really important just to make sure all assets are properly titled in conjunction with the estate plan, as well as to have updated beneficiary forms. As far as distribution to descendants, I'm now on slide 19. You can have an outright distribution. Oftentimes that's very appropriate if you have financially mature beneficiaries and see no reason to have ongoing trust administration, because there are costs and expense with that too. But the danger there obviously is you lose some of the asset protection. You could do time distributions to descendants, particularly children and grandchildren. I put down there, it could be 25, 30, 35. You can also have assets held in trust, in foreseeable future by their control, essentially by the beneficiary. I won't get into the legal mechanics of that, but obviously then we have the option to distribute outright at death or to hold in trust for a period of time. Oftentimes you do that for asset protection, but that can be modified based upon your wishes. Usually it's a trade-off of how much asset protection do you want to obtain for your beneficiaries versus how much time and expense you're willing to incur for that time period. Because you will have tax filings and some accounting and some financial oversight. As far as asset protection, in addition to, a trust-based plan for business interests will hold assets in an LLC, for example, limited liability company. We can also have, as I referenced earlier, irrevocable trust. Oftentimes, those can hold insurance. They can either, address any, potential taxes, expenses, or basically, particularly for this audience too, an irrevocable trust could be funded to keep assets outside of someone's estate for purposes of ensuring ongoing, public benefits eligibility, particularly for Medicaid.
I have a question.
Yes,
That's probably one of the most common requests we get is for information about Medicaid, and everyone says, well, I gotta whittle it down to $2,000. I gotta get rid of all my property and sell the car and the house and all this stuff. So if you could explain that that isn't the case for the spouse, and then as well as if I would put money in a trust, does that mean that the government, the Medicaid people cannot come after it?
all right, so a couple of questions, so happy to address those. So first of all, there's kind of different types of plan that can be engaged for asset protection, particularly if you're expecting to incur significant medical expenses. And so one strategy, the basic strategy you can employ is for Medicaid eligibility. You talked about there's an income level. So you have to become Medicaid eligible, you do have to report the assets you have for a Medicaid application to become eligible. And there are certain income constraints, but within that, you also have some exempt assets. So for example, your home is generally exempt, a vehicle for transport. And generally what we encourage clients to do is to maximize your exempt assets. So I always kind of hide the situation where maybe you live in a 2-story home that really hasn't been updated, for 20 years, and it's hard to get around. And given the declining condition for you or your loved one, you're not sure you can live there. Well, a way to use your exempt asset, let's say you have a home that's worth about $300,000. Well, maybe you want to utilize some of your savings to maybe buy a condo that's on one level, and maybe that's now a $500,000 condo or $600,000 home. You now just maximize your exemption amount that's not subject to Medicaid eligibility. Let's say you have an old vehicle. I say old, maybe it's 5-10 years old, and it's not worth a lot of money. But now you're want to have to go, get a transport van. Well, that's $45,000-$50,000. You use your resources to buy that. That's another exempt asset that doesn't count against your, asset eligibility for Medicaid. So oftentimes we'll encourage, and that would be, whether you would seek counsel for that to utilize your exempt assets or to maximize those exemptions as well. Which is truly a Medicaid planning discussion. You probably want to engage with an attorney or with counsel. With regard to protecting assets of the spouse, there is limitations as far as, that the community, what we call the community spouse, that could be subject to all of the assets being invaded. And just know, without getting into the whole mechanics of Medicaid asset protection planning, if you do get to the point where you're doing a Medicaid application, I would encourage you to seek counsel as far as using those exempt assets, but also being mindful of how to structure your estate plan in conjunction with Medicaid eligibility. I don't know. I think that gave a general answer. And I'm going into the next page here on slide 21. Just talk about kind of the main concern, and I would imagine for many people here, how to navigate long-term care expenses. There are basically 3 main sources for long-term care: private pay, long-term care insurance, and Medicaid. And under Medicaid is also for anyone who's a veteran, VA in attendance, which also could be a great resource as well. And I don't know if I want to go into the whole dynamic of, I can talk about the legal dynamics of Medicare and Medicaid, but I imagine you might have other speakers who can talk more eloquently about the actual benefits and how they're addressed. But Medicaid does provide benefits for a full spectrum of long-term care, with in-home care, assisted living, community-based residential facility. and, as well as their situation here.
Excuse me,
Yes, go ahead.
they only cover that once you get down to so much assets, right?
Yes, so, you are generally expected to pay, private pay, until your assets are expanded down and then you became Medicaid eligible. I think the main thing I want to communicate about Medicaid eligibility, we touched upon a little bit earlier, is know that there's also a 5-year look back period. So it used to be they basically become Medicaid eligible to disclose about your assets in an application. And it used to be a 3-year look back period to see if you've intentionally divested assets for the 3 previous years prior to admission to a facility. And they made that now a 5-year look back period. And truthfully, I expect that in the near future, they're probably gonna make extend that look back period too. So what that means is, let's say you have spent down your assets, you've divested your assets, given to children or loved ones or others. And then you have to disclose your asset level and then also disclose the last 5 years. And it becomes clear that you divested your assets. Then you either will have a penalty or you limit your eligibility. And then upon an individual's death, and they'll have engaged in what we'll talk about shortly here, what they call estate recovery. Where basically they'll make a claim against the estate for expenses that, or benefits that were obtained by the beneficiary. But that they had the resources to, and so they're going to seek recovery against the estate.
Mark, I have a question,
Yes,
actually 2 questions,
okay,
sort of about what you were just talking about, but I've been doing some phone calling, doesn't Medicare generally pay for hospice?
Yes.
that's my
And-
understanding.
Right?
Yes,
That's the way I was directed, and even if a person has a supplemental or a Medicare Advantage, original Medicare would still pay for that, right? They bill through Medicare, is that correct?
Medicaid is designed for population.
Right,
Everyone isn't expected to apply for Medicaid.
right,
That's only when the funds are very low.
but I mean Medicare, if somebody is, we have supplemental Medicare or Medicare Advantage.
So Medicare usually pays for about 80% of a
Right.
bill, and then your supplemental will pay, hopefully cover the other 20%.
And that would include hospice.
No, the Medicare hospice benefit
Please.
that covers hospice costs for staff, equipment, medications.
Okay.
And is there a time limit on that? How
I-
long do they pay? I mean,
as long as there is a decline in the patient's health,
okay.
they can stay on hospice care. That's in a nutshell. There's a
So
lot more.
it covers the hospice care, but it doesn't cover like if the person has to go into assisted living, it won't pay for the room and board.
Okay,
So,
okay.
and that's what'll probably eat up the money the quickest.
That's exactly right.
Then there was, another question, I don't even know how to word it, but someone had mentioned to me that because this can be financially devastating for people, that there's a form through your attorney that can be filled out where a spouse can put half of their assets towards the other spouse, and it's protected that way. There's a form that's filled out, something,
there's documents, yeah, we can prepare to address that.
okay,
So it's basically isolate the exposure of what we consider the community non-institutionalized spouse. So they're not exposed to having to deplete their assets. Yes,
okay, so there is that, okay,
yes,
thank you.
you're welcome. And then I'll just continue on here. As far as several of the investments on slide 25, I kind of go into a little bit of the details here. Significant change in the law occurred in Wisconsin back in 2014, and I touched upon here when I talked about estate recovery, and I think my emphasis there is basically just to explain that and it's not just in Wisconsin, but throughout the United States, that basically there's a more aggressive posture to recover from estates if it appears that people were, obtaining benefits that they would otherwise not have been eligible for. And so that's caused, a lot of concern, but also I think motivated people to do more comprehensive planning. And I just address here, how the state of Wisconsin, they're addressing state recovery post 2014. Excuse me. I think to the point brought up about Medicaid basis for long-term care. Just know we talked about, we can shelter a community spouse or non-incapacitated spouses assets. Let's say at a 50% interest in their property as it pertains to Medicaid eligibility. Going on to page 27, I kind of enumerate some of those exempt assets I talked about. So rather than spending down or something to divest, which often frankly is not a viable option because particularly with the course of ALS or other conditions, you don't necessarily have 5 years, 5-year window to divest. And even, if I'm not comfortable with recommending a lot of divestment, but even for my older clients, who knows when they might need long-term care needs and disabled, you get rid of everything and, wait 5 years. And I'm not sure that's a viable situation for many individuals. But just enumerate here on slide 27, the exempt assets for Medicaid. So these are assets that basically don't count into your asset eligibility. So your home, and I just talked about, upgrading to a larger home or a more functional home or house or condo, vehicle, face value of life insurance, like $1,500, what was stated, prepaid burial plans, personal property are exempt, business assets, a special needs or pool trust. That's something that I'll touch upon briefly. That there are, for example, Wisconsin, there's 2 what we call community pool trusts that are administered. One is known as WISPAC, WISPACT. Another one is based out of Madison, administered by a bank, I think in Michigan. And then another one is Life Navigators, which interestingly is based out of Wauwatosa. And then full disclosure, I'm the trust committee for Life Navigators. But the benefit of those pool trust is that's a way to have assets set up now. For example, Life Navigators and WISPAC, the individual can set up a pool, have an account in a pool trust, or a third-party individual, like family member, can fund a pool trust for the benefit. And the benefit of these pool trusts is, if I were to set up a special needs trust for a client, there's the cost and expense of that, but also the trustee has to have ongoing review of this to make sure it complies with the most recent Medicaid regulations and laws. And so these pool trusts fulfill a important function of, they're basically, it's a large pool trust that has many accounts, in fact, hundreds of accounts. And so in a pool trust, you can put assets in there, provide for a family member, a loved one, or even oneself, if you're declared to be disabled. And then those assets then upon death go back into the pool. But up until that time, those assets can be expended for the beneficiary designated by the settler of the trust or the person who created the trust, or that be funded by oneself or by a third party.
Question.
Yes.
Exempt items, your home, your vehicle, personal item.
Yep.
But are them items also exempt for the recovery of assets?
Well, the recovery doesn't occur until after
death,
death.
right?
So I guess to answer your question is the proceeds from those assets could be recovered. But while you're alive and while you're getting eligibility, those are totally exempt.
Okay.
Another exempt asset here, IRA and retirement benefits. Sorry, those are the big ones I've identified. There are others, but we'll enumerate them further. I talked already here on about slide 28 about the 5-year look back period. And then, there's some basics here, and I go back to my initial notes here, make sure we covered some questions and we'll open up for more discussion. As I said, this is a general presentation about estate planning, but I'm also sensitive to why been asked here and some topics that might be of interest. So I'm happy to entertain some of these questions, but honestly, what motivates people to plan? If they have a child, additionally, if they come into significant wealth, or if they have a significant event, either health wise or financial wise, that motivates them to plan. But truthfully, it's always important to think about how you want to dispose of your assets, how you want to have any kind of defined documents that should, say who should manage your healthcare, who should manage your finances while you're alive, and if you're incapacitated. So anyway, gave a brief overview of the course and trajectory of estate planning over the last 30 years. The fact that how we've kind of evolved from having wills to having more trust-based plans, and then having more aggressive planning, particularly for asset protection, to get assets outside of one's estate, if not for tax planning purposes, oftentimes to avoid exposure to creditors, and also for Medicaid eligibility purposes. And I think that my main points here are, I want you to think about estate planning being a comprehensive interplay of your documents and your wishes. So, the key thing for most individuals that we need to be mindful of is planning while you're alive for capacity. Any one of us, anytime, may not be able to express ourselves and express our wishes. Make sure that you identify agents who will carry out your wishes, even if it's contrary to your own. So, I always tell people, it may not, oftentimes people want to think, well, I should have my friend or my family member who's a nurse or a doctor or in healthcare, be my healthcare department attorney. I would just say that might be great. But ultimately, make sure you have someone appointed who's going to carry out your wishes, even if it's contrary to your own. Additionally, have someone appointed that can carry out your financial affairs while you're alive, but incapacitated, that will carry out your wishes once again. In the event that you have family members or loved ones be provided for, but they will also help be mindful of how to carry out your financial wishes to care for them, provide for them. And then as far as post-death administration, just being mindful of trying to achieve those goals we talked about earlier. Making sure they provide for your loved ones, promote family harmony, limit exposure to cost, fees, and expenses, show us avoiding probates, but also be mindful of how to maintain eligibility while you're alive for benefits and avoid things such as estate recovery. I'm going back to my notes here.
I think we turn the light on now, if that's okay.
That's great.
See each other.
So I want to just talk about some of the questions that maybe I didn't address more fully. One concern was about providing for a minor child. Obviously, a trust-based plan could be devised, and I use oftentimes for clients who have young families, whereby a trust-based plan we have established provide for both husband and wife while they're alive. And then if one passed away, becomes incapacitated, provide for both spouses if they're both alive, but one incapacitated, provide for the surviving spouse at death. And then additionally, to hold assets in trust after the death of the surviving spouse. And generally, a typical estate plan, we would hold assets in trust for a young child until they're, it could be just 18, but oftentimes it's assets held in trust until 25, 30, 35. And then we identify who's going to be the trustee for that. So whether that's a close family member or friend, or it could be a corporate trustee. And oftentimes that's advisable because for a young child, and I know, sir, you said I have a 2-year-old myself. I had to be mindful in my own estate plan. I'm not sure a corporate trustee can help out there, because in 30 years, if I pass away, I don't know who else is going to necessarily serve, because a lot of my brothers and sisters happen to be older than me, and most personal friends are my age. So Anyway, definitely can do planning for young families, individuals. In fact, a trust-based plan usually is really good for young families, because they need to make sure that the young one is taken care of, but also that the assets are protected for a period of time. Asset protection, we touched upon in different forms today. I guess the main takeaway there is for Medicaid eligibility, long-term care expenses. For more comprehensive discussion, I'm happy to have it with you or seek other counsel to discuss about using those exempt assets, but also, developing a strategy if you want to take a more aggressive posture and transfer assets to an irrevocable trust. Additionally, just being mindful that short of having assets divested, not be able to wait 5 years, what you want to do is make sure that those you want to provide for, maybe have asset protection for them by having them not receive the assets outright, but to hold it in trust. Current example, once again, is going back to the minor child situation where we clearly would rather have those assets held in trust for the benefit of that child if they're a young adult rather than just outright exposed to any predator or claim. There's a question about, is a will enough? I guess my response would be a will is better than nothing, because a will expresses your wishes. And as I said, without a will, your estate plan is basically the state statutes of wherever you are, in this case, Wisconsin. And so the issue about, well, who's to receive? What if I have stepchildren or it's a blended family situation? Clearly, you can address that clearly in a will or a trust document, and that's without those documents. For example, those individuals would not be provided for someone's estate. There's a question generally, as I see in my notes, about Title 19 effects on assets. And so I may have touched upon that in a very general sense from the standpoint that to be Medicaid eligible, you do have to disclose all your assets. And yes, you can consume a lot of your assets for long-term care needs. Admittedly, there's limitations on how you can effectively shelter those assets, particularly if you're looking in a 5-year window. But we do utilize tools, and those tools allow those exempt assets identified. And then there's a question about healthcare powers of attorney and guardianship. So generally speaking, you want to avoid guardianship. So you want to appoint agents to carry out your healthcare wishes while you're alive and incapacitated. If you don't have a valid and current healthcare power of attorney, then what has to happen is there has to be a guardianship proceeding, whereby there's a hearing and the court has to appoint someone to oversee your healthcare or your finances. So over the years, I've been involved in, probably over 100 guardianship proceedings, and sometimes as a petitioning attorney, sometimes as a guardian litem. These are for adult individuals who are incapacitated. So in those situations, if someone doesn't have a healthcare power of attorney document and they land in the hospital and they're in critical condition, one of the local hospitals, the local hospital will petition for guardianship. Will have an emergency hearing, usually within 24 to 72 hours. And the court will appoint someone to be guardian. Generally, it would be an attorney or a social worker from a social service agency who accepts guardianship petition. So that's generally not preferred. You would prefer to have someone and trust to be your agent, rather than to leave it to chance that a court official, in a very critical situation, needs to appoint someone who doesn't know you at all, or your wishes to be directing your care and treatment. So generally speaking, once again, thinking about estate planning being comprehensive, we want to make sure you have updated healthcare power of attorney documents to direct your healthcare while you're alive, financial documents to direct your finances while you're alive, and to have an overall estate plan, which probably would be a trust and or will to direct your assets upon death. So we want to avoid guardianship if all possible, because by having your wishes fully expressed in your documents, you can make sure that hopefully your wishes are respected and carried out. So those are those questions. Now, I'm happy to open it up to any other questions, either in person or on the video screen.
I'll try. a few years ago, I was the executor of my mother's will.
Okay,
When probate never was mentioned by anyone. My,
okay.
my figure probate.
He wanted to know, he was the executor of her will and probate never came up. What would have triggered probate?
So that's a great question. What triggers probate is having over $50,000 in the decedent's name at death. Okay, so what can happen from time, so usually what triggers most probates for most states are a home, because most homes are $150,000. But if you don't have, let's say someone's in an apartment or a nursing home, they don't have a home. Well, they could have transferred their retirement, their IRA, their 401k. The bank accounts could be payable on death. So everything could have flowed outside of their estate, or basically they don't have $50,000 of assets that don't flow that way. So, usually if it's not a home, a vehicle, vehicles now. A vehicle.
Well, hers, they were about $100,000.
Okay, her estate was about $100,000, you said. Was it in Wisconsin?
Yeah.
But did any of the assets flow through beneficiary forms or designations?
No.
Well, my suspicion would be either, I can tell you as a matter of law that, if either they probably would have flowed through beneficiary designations, or unfortunately, at some point in time, someone may have to do probate. Like I have unfortunate matters over the years where someone says to me, Mark, my loved one, my mom, my grandfather, they died 5 years ago. And now we're gonna sell this real estate. Oops, it's still in the decedent's name. So now we have to open up a probate 5 years later or 10 years later. So I can just tell you that the right letter law is basically, it's really hard to transfer assets. A bank or a title company won't let you transfer an asset unless they have clear title of someone who's alive or has authority for an entity. Any other questions or concerns?
My wife and I are on the mortgage.
Right,
When she passes away, I believe that transfer is just to me after.
yeah, so great question. So as long as you're a Wisconsin resident, so we'll just make the assumption you're a Wisconsin resident, you're subject to marital property. Which means in Wisconsin that absent a marital property agreement or a prenuptial agreement, every husband and wife or spouses have an undivided 1/2 interest in their real estate. So effectively in that situation, if the house is deeded in both your names, or even frankly, if it's just deeded in one of your names, and survivorship marital property, it will go to surviving spouse. So typically the process there is, if a husband or wife, one of them passes away and they're both deeded on the property, then in Wisconsin, we complete a form. It's called a termination of decedent's interest, or called the HT 110. But basically what that happens is after one spouse passes away, we complete that form, we record it with the register of deeds, and effectively acknowledges that the surviving spouse has full ownership. But I would say if you do revisit your estate plan or put together a estate plan, you'll want to look at that, the attorney who's working with you will want to look at that deed, just to see how it's titled. So go ahead.
And then the other thing is, we were fortunate enough to get a decent mortgage. Can they come back and change that mortgage if we're missing 1/2?
Well, that's a great question. I had a meeting this morning addressing that very issue. I've got a husband and wife passed away. So generally, so mortgage is a matter of private contract between individuals and the financial institution. But truly what governs that is the mortgage itself. Okay, so you have to, review the term of the mortgage. As a practical matter, I will tell you that as long as a financial institution is getting paid, they're probably just as happy to keep it going on, to get paid. And it's actually, this time we're living right now with interest rates all of a sudden going way up, it's going to be more of an issue because clients clearly don't want to refinance. And when rates were relatively consistent, was it 12 months ago? When they're relatively consistent, it was not a big deal. You basically retitle the asset and then you secure a mortgage at comparable rates. Well, that's hard to do now. So, I guess I want to say on the record here for everyone, as long as the mortgage holder keeps getting paid, they're probably fine. But ultimately, if you ever sell that property, you'll have to be resolved, because it needs to be resolved who has clear title to it. And the title to the property, the deed should sync up with the mortgage holder and mortgagee.
So what if it says on his mortgage, husband or wife? Or does it have to be always written out husband and wife?
Well, truthfully, it just depends how like, for example, like this matter I was looking at earlier today. In that instance, we're looking at the one spouse was able to had better credits, and also the other spouse had a business and wanted to protect liability. So the mortgage and the deed were intentionally just in her name, okay? For both asset protection purposes and also for finance purposes. And so that creates an issue. But to your point, the mortgage could have been titled in both their names as survivorship rental property. Probably would have been preferable, but it would have gotten the asset protection.
Would you recommend he go to his loan institution and explain them to them the situation and see what they suggest?
You could, but be careful.
Yeah.
Because here's the problem is if they have knowledge of that, their concern as a lender is basically they want to make sure that note is paid.
Right.
And so if a probate's open, they're gonna get notice of if a probate's open to clean up the title, they would get notice of the probate action. And they probably would file a claim because they don't if they don't file a claim, they're gonna potentially not get paid on that note. I guess my recommendation, without getting into particulars here, would be, if at all possible, try to, well, you can contact your lender, but I would maybe seek counsel first and see how much, that's why I'm navigating right now with a couple clients, because once they become aware of that status, then they have a risk mitigation issue where they want to make sure they're gonna get paid on that note.
The status of the criminal illness?
On the fact that, well, I think that would be okay, but the fact that if there's concern that, I don't want to get too much particular because it's
No.
personal, but like, I don't know how it's titled. If it's titled in joint names, it's probably not a big issue. If it's titled in just one name, it gets to be an issue, and that's what I'm working through with the client right now. So yes, you could talk to your lender, but you should be advised that once you get that information.
You can't take it back.
Just be honest with you.
Okay, thank you. Appreciate
You're welcome.
So we have a question in the chat.
Yes.
For a minor child with a trust, should the trustee be a different person than the child's guardian? Advantages and disadvantages for each of them.
So that's a great question. Comes up very often. So I always tell clients that is a matter of preference. So some people, they'll appoint trustees because they'll say they're financially savvy, or they'll appoint the appropriate people, financial advisors, accountants, attorneys. And so I trust them, but they wouldn't be a good parent to my child. Or some people would say that would be a great parent to my minor child, but I wouldn't want them managing the finances. So I always say you have to the clients might have more insight about this than me, but I would say, so some people feel like it should be distinguishable. You should have guardian be distinguishable from the trustee because it's kind of a check and a balance that, the guardian can focus on parenting, so to speak. And the trustee can manage the finances and as long as there's a good communication, the guardian can always go to the trustee. They should be able to and say, we have these needs for, education, care, camps, whatever, and should be an issue. But the other school of thought is maybe have it be one and the same because they can take care of the child, but also, or the capacity individual, also have access to the fund. So it's a great question. It's a great point of conversation with clients. And I always just say that we just assess who you're identifying. And the clients would always have more insight about this than the drafting attorney. Should it be distinguishable trustee and individual subject to guardianship or a minor or not? So it could be the same or it could be different. Sorry, depends, right?
Uh, My parents set up revocable living trust,
Okay,
and they set up as successor trustees. There's 3 children,
okay,
myself, my brother and sister.
all right,
And they did it with a lawyer who worked in estate planning in York County.
okay,
Where my parents lived. And it worked out very well when first my father died and my mother took over the trust, and then she recognized she was getting dementia. She resigned as a trustee, and the 3 children took over. And there were some issues between us over handling finances, but the rules of the trust constrained us to following my parents' wishes, so it worked as it was supposed to. I chose from that to get together with my wife and set up a similar trust. After we had done that, Orchard was diagnosed with progressive bulbar palsy. And some things changed, but actually the trust seems to be flexible enough to be able to handle that for us.
good,
And all assets are in the trust. We don't have any outstanding mortgages or loans, but an asset like a house now is listed under the trust, and our 2 daughters are now set up as successor trustees. It's sort of the familial approach to trustees rather than the bank approach. My mother-in-law used a bank, and my sister-in-law is developmentally disabled.
right,
My mother-in-law died. Her entire set of assets went into a special needs trust for my sister-in-law. Chase Bank was no longer into those and never let her know that, and we had a god awful mess extracting all of the issues from that. My wife could not write any checks to pay off creditors after my mother died because of the lack of having that set up. So the best laid plans you can lay down can go to waste when things happen in different places. Who would expect Chase Bank to have screwed up like that? And one Chase banker came in and really apologized to my wife for having messed that up and not letting her know beforehand. I mean, that was all straightened out, and the result is that we now have more experience in how to work with this. And our 2 daughters have some experience with us at looking at this and realize very much what they're getting into their 40s. With both of us having, I've got diabetes and my wife has ALS. But in looking at all of this, I think what I'm most concerned about now is not so much some of the financial, I think we've got a handle on that. But it's more getting directives clear. Like my father had to do not resuscitate, my mother couldn't stand it and had resuscitated.
And that's something that comes up, Mike, quite a bit. And we really urge people to choose agents that they have talked to and that know their wishes and that can actually follow through. If they can't follow through, don't pick that person. You know, you don't have to have your wife, you don't have to have your child.
Yeah, but that's a hard one to drop off on when you've been married for 70 years. And, but it worked out.
Yeah.
I mean, basically, my dad could communicate by blinking his eyes after he was resuscitated. And my brother and I had 24 hours to get from Wisconsin to Florida to spend an evening with him before he said, I'm done. And they unplugged the ventilator. And it was
Awful.
no, it wasn't.
No.
He said his goodbye. We were all there. My mother had no guilt. I mean, if you just unplug a ventilator yourself with someone who is unconscious, you always have questions about that. But he made the decision himself, and it cleared everything up within the family. And it actually is left, I think, well, my one daughter has no children, my other daughter has 2 children, that's it in the family. But they've now gone through all of those different experiences, and it has them in much better position to look at what our wishes are gonna be is we're both retired going through this. And my result from all of this is I really feel positive if you have assets and you can afford going through it that way. Of looking at revocable trusts, I think they're very powerful. I mean, our total assets for my parents were under 500,000, but they set theirs up. Ours were under that when we set ours up, and it still, I think, was worthwhile sitting down with a lawyer that had that experience. But you do have to really understand what your goals are and your needs are, and have a lot of, really good conversations. And we've been really fortunate in being able to do some of that ourselves.
Well, I think those are excellent points. I do want to address, you raised, we'll address
No, go
that, but I
ahead.
want to, while it's on my mind, you raised some really salient points, which was, first of all, to your point about the 3 co-trustees, that's always interesting because, oftentimes I'll defer to clients, you have co-trustees or not. Unfortunately, I've had to do administrations where we have 2 co-trustees, family members, they hate each other, dislike each other. I have one case that has been litigated for years just because they don't talk and they despise each other. Yeah, it's terrible, but it is what it is. So,
Isn't that sad?
That's me and my brother.
yeah.
Oh, really?
So sometimes people have 3 and then it's actually chicks and breaks the tie. You had, what we try to direct in there is some kind of contest clauses because otherwise it's just a bottleneck. And that, nothing would, for example, I know this case I just described of my clients with 2 brothers who don't talk. That would be the last wish their parents would have wanted of this, dysfunction mitigating and creating this long issue. To your point about corporate trustees, it's interesting because 20, 30, 40 years ago, the large banks, M&I, Chase, they would have a trust officer and they would have been there for years and you would get to know that individual or that team, whatever. Well, those days have really changed, but going back to even particularly back to 2008, 2009 with the financial crisis, with the banks merging and whatnot. A lot of the trust offices aren't even here. Obviously, we know that M&I became BMO. They have trust officers down in Chicago. If it's under a certain dollar amount, they don't want to serve as trustee because financially does not make sense for them, they believe. Like PNC, they have a trust office, I think in Detroit or Pittsburgh. So I will say this to your point, I think it's just counseling, seeking counsel with an attorney. If at all possible, I generally steer clients towards having individual trustees, usually a trusted individual or family member that can retain professional services. So, they can retain a financial planner, a financial advisor, an accountant, a lawyer. But that way ensures that the intent is carried out and that the trust assets are needlessly expended just by a corporate fiduciary who's just sitting on the matter. So those are excellent points on those 2 fronts. And then I appreciate you sharing with everyone here, just good planning. It really expressing yourself clearly in the estate planning documents. With a local living trust can really be powerful to carry your wishes, but also to efficiently administer your estate. So thanks for sharing your experience. And I have to touch upon those points.
I will say my daughters, neither of them would want to be singularly trustee.
Right,
They want to be able to share it so that they feel that together they have. Now, our daughters get along well.
right, right. And I always tell clients, you have more insight into these individuals than myself. So I had to, ultimately I got to defer to you. So it can work seamlessly and that could be one of the desired objectives of the beneficiaries and the children working together, and that could be desirable. Sometimes it doesn't always work that way. And then with regard to corporate trustees, there's just some instances where a corporate trustee makes sense. I've also had clients say, Mark, I don't want to be the family banker. And then I'm the uncle to the niece I don't have a relationship with. I don't want to be the one who's trustee for that. And they prefer to have a third party neutral, often as a corporate fiduciary. My older partners, they would be more willing to have served as trustees. Myself and my current partners were many attorneys are very reluctant nowadays to serve as a trustee because of the fiduciary liability. And the same thing with most of the other financial institutions, but before they have a dedicated trust company. So, good points. I'm sorry, you had a question or concern.
Well, since we're kind of new at this and how? What are we talking, if you need an estate lawyer, and how much does it cost to set up a trust and go about finding someone to do this? And well, we found you,
Yeah.
you want to be said, I said, I'm not gonna ask this question, just how much do you cost?
Sure.
But no, I mean, how much does it cost? We have a will, but if you want to set up a trust and we need to go into estate planning. What are we looking at?
Sure, so I will say, I can give like ranges.
Yeah.
So they're-
Basic.
So I'd say, like, an estate plan for a married couple, with children, could easily be, $3,000 to $5,000. If we add on to that, different variations of that, could be another $1,500 here or there. I do, a lot of my work is billed hourly. So like, for example, my hourly rate's $380 an hour. My paralegal is $200 an hour. But. and
What
we
if it
have-
was for someone, excuse me for interrupting, but what if it wasn't for a husband and wife and they had kids? What if it was just for an individual? How much? is it?
I mean,
Is
if
there a
we're
difference?
doing a trust-based plan, probably, at least 1,500 to 3,000, I'd say for a married couple more, 3,000 to 5,000.
Okay,
So just, kind of give a range to get started with.
That's where we were with ours, for that kind of range.
Okay,
Okay. So that kind of basically is
That sounds good.
pretty average, because I think my
let
sister
somebody
said
else.
she said it up, and that's basically.
It can seem like a lot of money for a really.
And based on
Yeah.
And at the same time. When a revocable trust is generally set up. That the assets go out to the successor trustees at the end, and that kind of ends that trust. At least that's the way it was with my parents. They could go on, but it didn't, and it worked. I mean, I wrote the final distribution of resources between my brother and sister and I. And my sister fought both of us.
Mhm.
But the rules that were set up in the trust, which is why you put that money up front when you're setting up the trust, constrained us to operating within those rules. And so. None of us were outlandish. We could argue with each other, but we had to operate within the rules, and it was an equal division. Which made it easier, and in that sense, having the trust down in writing gave us that blueprint when we went through it.
and to, I also just want to add on to that point, which is just know that if you don't have an estate plan, or if you have a will that's going through probates, just because the probate's very time consuming, documents to file, and court appearances, it's really hard to do any probate if it's small or large for less than $5,000 or $10,000. So I think the value proposition gets back to what I said earlier of, you can pay for it upfront, the value you derive upfront, and it'll be less expensive to you and your estate. Post death, just to get started with the probate can easily be $5,000 or $10,000 or go tens of thousands of dollars. So a probate is not necessarily cost effective. Now, trust administrations can cost money as well. And let's be straightforward about that, but just to kind of, set parameters of like thinking about cost, fees, expenses. There's a greater, you might pay more upfront in theory, with a trust-based plan, but on the back end, it should be less costly.
Is there, this might be a weird question, but there are a lot of estate lawyers. How do you know, like, you have worked with people with ALS, there are some, should we look for somebody like that, or do you know, how do you know how to pick a
Sure.
good one that's, obviously we know you now. so-
Thank you. Let's thank you.
Because I mean, somebody that would know how to meet the needs of people that
Sure.
are going through what we're all going through.
So, and I don't know, like, for example, the ALS Association, I know certain organizations do keep a list of attorneys and whatnot.
No.
I know, like, I'm not sure if that could be pros and cons. I would say in the state bar of Wisconsin, like, there's generally, now I focus on my practice on estate planning, so I'm biased in saying that, I would recommend try to seek counsel, seek an attorney. Whose focus, most of the practice is estate planning. And, for those of us, in larger firms, generally we define, as having a trust and estates practice. The interesting thing about trust and estates work, it could be in a small firm, a large firm. Interestingly, I've lived on both ends of the spectrum. I'm now part of a 200 attorney plus firm. I also, I've been a sole practitioner 15 years ago. I had my own office too. So it's a good competent estate planning. I want to encourage you to get recommendations from others and look for people that there's not a good repository. So usually the state bar website will, indicate what your specialty may be. Or there's national organizations too. That can facilitate that. So I guess my main piece of advice is seek insight from others and then identify if you truly are interested in estate planning, seek out a estate planning attorney. I would also go the extra step of saying, particularly for this group, if you do have concerns about asset protection, Title 19 Medicaid planning, traditionally that's known as more elder law, whether or not you're serving elder law, those are more. So most attorneys do focus more on disability planning, will also call themselves elder law attorneys, okay?
ELDER.
Correct, ELDER. So if you're truly looking for asset protection, Medicaid eligibility issues, you might want to find someone who defines their practice as not just being estate planning, but elder law. Much of my practice is more what I consider more traditional estate planning. But I do delve into elder law, asset protection planning, special needs planning issues in my practice. So hopefully that gives some insight. I'm reluctant to give more clarification because I don't think we really have a good list. I know other organizations I'm affiliated with, sometimes they have a list of attorneys who are affiliated with them, but those are my general insights.
Thank you.
Sure.
Well, Christie, I haven't lived in Wisconsin that long, but I understand it's a marital state, so, what happens, like, my husband has credit cards in his name
Okay.
and like medical bills in his name, and what happens to that, and is there any stipulation, like, in a lease, like, do we have anything, recourse, I guess, maybe?
Are you both in Wisconsin now?
Yes,
Okay, and how long have you been, I don't want to get too personal here. but-
we've been here about a year and a half.
So you're Wisconsin residents and you're subject to Wisconsin real property law. And what you're trying, do you want to limit your liability or expose?
Well, I mean, when he dies, am I gonna be responsible for his credit cards and medical bills? For his credit card debt?
Potentially, you have an
Okay.
undivided 1/2 interest in each other's assets and liabilities.
Okay,
To the extent you still have assets, you have assets, what state were you coming from?
Illinois,
Okay, so Illinois is an individual property state. So to the extent you may still have assets in Illinois, you may want to seek availing yourself of even if it's segregated, but that's challenging now if you're truly Wisconsin residents.
okay.
Yes,
Is that one of the, this example, is that one of the instances where that form that I had asked about, the sheltering 50% for your spouse? So if something happens down the road where your husband is incapacitated and long-term care, and you are protecting half of your money.
yes.
Is that, and what is that form called? even?
Well, it's not necessarily a form, and we could petition the court to segregate the assets, but the challenge, and we're getting very particular here, but particular facts that may doesn't apply out. The challenge is you have liabilities that predate we can segregate assets for eligibility purposes and consumption of assets from a community property spouse when I say community property spouse, I'm not talking about marital property, I'm talking about just an institutionalized spouse who's basically drawing down their assets from Medicaid, and long-term care purposes versus a community spouse who's out in the community and not drawing upon those benefits. The challenge presented here with those facts are if you incurred liabilities that are now subject to marital property, that has to be addressed apart from that. They're two different, they are interrelated, but they're distinguishable.
Oh,
Okay,
That's all I can say is if there's already liabilities you already encountered, those are still marital property. assets
Okay.
and something like
So that estate is responsible for those bills if he passes away.
Yeah, I mean, I'm concerned to go much further because I don't know any more details. I don't think it's appropriate value to kind of go into those details right here, but you probably should address that sooner or later.
When my parents moved to Florida,
Yes,
they got to know people where they were living and took the trust to a lawyer that was recommended by people who worked with them. And there are slight differences between states for different trust laws. And
absolutely.
it was good for them to go through and clarify minor changes that would be required for the trust based on Florida rather than Wisconsin, which just sort of cleared having a problem on that with the trust. Florida.
Absolutely, and as I say earlier, I do have a number of clients who have become Florida residents. And for example, in my office, we have 2 or 3 trades were licensed in Florida, and so we work collaboratively. Florida just modified their trust laws last year, so in particularly addressing this issue of we have barrel property in Wisconsin, and now in Florida, they've now availed themselves of some similar community property provisions. So absolutely, if you're dealing with assets in different jurisdictions, you might, I see someone who can address, assets in both jurisdictions. Even if you have assets like in Florida and Wisconsin, your situation is only unique because if you're not Bowling or in Illinois, but yeah, jurisdiction is important and it does vary state by state. Yes.
Have a family member, who's never been married, so he's got his property and lawnmower tools, all his other cars that he was gonna restore and never got restored. Are we, and he'll end up on Title 19,
Yeah,
are we better off selling them assets now or after he passes? Or does it matter?
he's at Title 19. The question is.
He isn't on Title 19
He's
yet.
not, but he will be
He
using
will be probably in about 4 months.
it. What particularly, what kind of assets are these? Is the vehicle?
It's his lawnmower, bunch of
Personal
tools,
property.
personal property, basically.
That whole,
You guys want to take your masks off? Go ahead.
oh, yeah,
This
No.
was the main one.
Yeah.
right,
Okay.
I'm
Sorry
sorry.
about that.
Yeah, we're trying to decide, should we sell the assets? Some of these assets now to pay for his care and hold off Title 19, or are you better off? Let him go on Title 19 and,
Well, I think like the distinction is like how much, I don't know how much are they really worth? I mean. If it's really gonna materially change the eligibility, then I would say hold off until they pass away. It's not gonna change the eligibility. I don't see what the harm is.
Other than his property, the land.
the land, yeah, the land, we ain't gonna worry about till he passes. And his home and, property.
So. I don't really know like what the value we're talking about here. That's, and I'm not sure, I'm asking you to disclose that right
Let's
here.
say, maybe, well, no, let's say 10,000.
Okay. Your question is, you want to address it now, like before we pass away, or wait till after later?
Right.
I think he's are you worried about Medicaid getting that money that the property's worth?
Yeah, but either way, yeah.
I would probably address it post death, but that would be fine. That's my general thought about it. Just
Okay.
probably not gonna cause much harm, and I don't know if they're really gonna try to recover that, so I wouldn't be too concerned at that point. My concern is if the money shows up in his bank account.
Right, and
yeah,
they can,
Yeah, then he
they
loses.
can lose
eligibility.
that, yeah.
So I think the safest thing is just to wait post death.
Wait, just-
That's the safest
I
thing.
thought about that later. So, okay,
Wow.
Yeah.
A lot of good information.
Yeah,
Thank
thank
you.
Thank you. Well, thanks for the invitation to come back.
I am.
Happy to be a resource. I'm always happy to be invited. So, I gave you the slides. Feel free to have as a reference.
Yeah. yeah.
If you would like to follow with me, my contact information is on the front page. I do, in fact, my firm just merged effective November 1st. So I don't have I have my old cards, but it's my
That's
only
right.
thing-
Is the phone number the
my
same?
phone number is exactly the same. And my office is the same. It just, we're now Davis and Davis rather than Davis and Kuelthau.
Okay.
We didn't go with, thankfully, Davis and Kuelthau. So I'll pass these around if anyone's interested, or whoever wants them.
Yeah, I'd like one.
Certainly.
I have a tip. Because, the hand strength of someone with ALS often declines and then they can't hold a pen, they can't sign their names anymore. So if you go to like an Office Max with your signature the way you want it, they can put it on on a stamp. And then that way, that person who has no stamp in their hands, then they can sign things still.
You know, nowadays you can do
a good idea.
anything for a signature.
I do.
My daughter was
Right.
one thing, she said, okay,